This is the last day that you have with me. We have a full schedule, so we'll be going through a lot of things today, and I think it might be that you at some point feel overwhelmed by everything that is going to be thrown your way today. But please bear in mind again that these are basic principles. So what you should be able to do when we're done today is you should be able to take a step back and say, I understand the civil procedure from an action being instituted right up to trial. We're not dealing with trial procedures in this program. I think there's at some point you'll deal with trial procedures and things at a later stage, not with me. I'm dealing with you with the civil procedure from instituting an action right through to trial. And the most important part thereof is you must understand the sequence of pleadings and the basic principles relating to pleadings. So how pleadings are exchanged, when they are exchanged, and what the purpose of these pleadings are, and the requirements for these pleadings. You don't need to be able, after this is not a legal drafting course, you don't need to go and draft a particulars of claim with exact precision, but as a judge you will be faced with particulars of claim and you need to know whether they were drafted with the requisite precision. Then very importantly is you need to understand fully the judicial case management system. Now, reading it on paper, and I know exactly how you feel, because as practitioners coming from a previous dispensation where we didn't have case management, it was a completely foreign concept. And I remember the first time I sat in a meeting, and remember I'm a litigant or a representative of a litigant who appears in court often, so I understand the procedure because the only way to really learn procedure is through experience. But the first time I heard the term judicial case management and I read the proposal on paper, I thought, what is this? How is it going to work? It's never going to work. We were all very concerned. And once we saw it in practice, it makes a lot of sense. So what I'm trying to convey to you is what happens in practice, because that really brings this abstract idea of judicial case management to something concrete that you can work with. So I understand, and I'm sure in the exams we will keep that in mind, is that you don't many of you haven't practiced or haven't witnessed the practice of judicial case management in practice. It really is as simple as I try to make it. It's just that when you read it on paper without seeing something concrete on the ground, it can seem a bit daunting and abstract. So just to catch up where we are, I told you yesterday that judicial case management happens in 3 phases: the case planning conference, the case plan and the case planning conference, case management conference, and the pretrial conference. So these are the 3 stages of judicial case management. This starts right after notice of intention to defend is filed, so there's no need to case manage an unopposed action. It's unopposed. Default judgment is going to be granted. So it's unopposed, no need to deal with, to judicially manage that case. Once an action is defended by the filing of a notice of intention to defend, automatically this process kicks in. Automatically it's docket allocated, so automatically that file is allocated by e-justice to a judge, and the judge then is seized with the matter and with the judicial case management of that matter. And then the overriding principles come in. That's where you need to understand what the overriding principles of case management is. Why do we have this system? We have this system so that it's judge-driven to get the ducks in a row. The judge isn't going to get the ducks in the row for the litigants, but the judge is going to force the litigants to do that within a reasonable time and in the most cost-effective manner possible. So it really is that you should have a pragmatic approach to managing cases. It happens often in practice that the permutations of a case and the idiosyncrasies of a case dictate that what the rules prescribe don't necessarily always fit into what needs to happen. And in those cases, you need to understand that you need to regulate the management within the bounds of the rules and sometimes make exceptions to the rules. Remember, inherent jurisdiction, regulate its own procedure. The court is there. The rules are there for the court is not there for the rules. So you, unlike a magistrate's court setting where you are very much kept in line by it being a creature of statute and you have to operate within the bounds of that statute and you can't regulate your own procedure, etc., etc. Unlike that, you're in the High Court now where you are able to manage. So it really is getting a feel for these objectives of case management, knowing what the rules are and knowing how you can work with those rules and sometimes outside those rules to make sure that justice is done between the parties and the speedy and cost-effective administration of justice. That is, in a nutshell, the purpose of case management. So in the example I gave you yesterday, you saw that in certain instances, for instance, with the case plan, it may be that you have to revisit that or that rights arise after the case plan. These things happen in practice, and you need to know how to work with that and around that. All right, so case planning we did. Docket allocation, Rule 21. I'm not spending a lot of time on that. You need to do that self-study. Know that once a notice of intention to defend is delivered, then the matter is docket allocated to a managing judge. Once a managing judge has been appointed, that managing judge will be seized with the matter throughout this process, unless it's handed over for whatever reason. Perhaps there's a recusal or the judge is no longer available or whatever. But generally, once it's allocated to a managing judge, that managing judge will deal with the matter and be seized with the matter. That is not to say that that judge must hear the matter when it goes to trial. So the trial judge may be someone different, because what happens in practice, matters are set down and all the floating roll matters are called by what we call roll call on a Friday, and the judge who's sitting in a roll call will hear which matters are proceeding. All those matters will then be distributed amongst the available judges to do the trial in the coming week. So it's not to say that the judge who is seized with case management will then also conduct the trial. That's not a rule. All right, so we did case planning conference, Rule 23. We dealt with how it's submitted, when it's submitted by whom, and the effect of not setting out a procedural step. He just picks up where the other judge left off. So it happens sometimes that they go on leave or become ill or whatever the reason may be that they're no longer available, and then someone would stand in and just carry on where that judge has left off. Okay, so then we dealt with the case management conference, Rule 25, which also these two don't really deal with a lot of the substance of the case. It deals with purely procedure, or perhaps better to say logistics. Both of these deal purely with logistics. It's not going to deal with the merits of the case. It deals with logistics. What are you going to do and when you're going to do it? This one is logistics prior to close of pleadings. And this one is logistics after close of pleadings. Okay, that's what we've been dealing with yesterday. So it's logistics. If you look at what is set out in the case plan and in the case management report, then you'll see that it is really just dealing with logistics. Who's going to do what? And why are they going to do it, and when are they going to do it? That's what's happening. Now we're moving over to the pre-trial conference. Now here we're getting into the thick of things. Here we're dealing with the essence of the matter. And we're basically getting the matter ripe for trial, and we are crystallizing the issues. Okay. So this one is the big brother of these two. Okay. So generally, what would happen in a case management process, in order to curtail costs, when it's a sort of a run-of-the-mill type of action that is also that I'm now instructed in as instructed counsel, then I would leave these two over to the instructing practitioner, the lawyer. He or she would ask my input in the dates and certain issues that may arise. But generally, this is sort of a not very complex procedure, and that can easily be dealt with. And also appearances are then done by, more often than not by instructed counsel in order to curtail costs. I would appear in a case planning conference or in a case management conference where it's a matter of complexity or issues arise that I need to address the judge on. But for the run-of-the-mill, no issues, there are no issues to really be determined or to address the judge on, then the attorney will generally deal with these. But here you need to sit down. Here you need to think. This is a much more complex procedure, and that's what we're going to deal with today, starting off, is what we call the pretrial. Okay. So you can, let's just, matrimonial matters. Remember that in matrimonial matters, there are additional issues that you need to address in your case management conference. I'm not going to deal with them, but you would be able to find them in the rules. And then also status hearings we spoke of briefly yesterday. So status hearings can be called by the judge. They can be called by the parties can request the judge to call a status hearing. So they don't call status hearings, but they can request the judge seek an indulgence for a status hearing to be called. And status hearings, as I've said yesterday, are called in order to determine the status of the matter, to address an issue that may have arisen prior to the next hearing and something that needs to be addressed now. So it's a very handy tool, and it assists the parties. It provides a mechanism through which both the judge and the litigants are able to keep abreast with what's happening and deal with issues as they crop up. All right, and then you get the pretrial conference. So the pretrial conference, it's Rule 26. It relates to the final set down of the matter. So essentially, a matter shouldn't be set down for trial until the pretrial conference has been finalized, and there's a pretrial order made. So what the parties are required to prepare when it comes to the pretrial conference is called a draft pretrial order. So it really is, and the parties prepare what they think the judge should order at the pretrial conference. Now, of course, in all these scenarios, but particularly in this scenario, the parties are required to meet. Now, obviously, that doesn't always happen in practice. The parties don't actually always sit around a table, because if it's a run-of-the-mill type of case, a normal motor vehicle accident or whatever, the issues are fairly straightforward. Then the parties, the dominus litis, the plaintiff, would usually draw a draft pretrial order and then send it to the defendant to look at and to see whether they want to make additions or changes. And then the parties sort it out amongst themselves. In more complex matters, you would find that the parties meet already at case planning stage and at case management and a pretrial. So, of course, it is, it is, of course, prudent that the parties meet. And this shouldn't be overlooked. The importance thereof, many issues may be discussed and sorted out during such a meeting, but that essentially is what the process prescribes. So you'll have the parties meet, and what they do at a pretrial conference, and let's just open Rule 26 for the moment. So a trial, as you will see from Sub-Rule 1, a trial cannot be, or matter cannot proceed to trial or hearing unless there's a pretrial. Now, of course, you won't do case management of interlocutories in that you have a case plan. If it's an interlocutory matter, you're all acquainted with the term interlocutory matter. Or is there anyone who wants me to explain what the term interlocutory means? All right. So interlocutory would mean it's not a substantive application, so it doesn't exist in its own right. It's subject to main proceedings. So if there were no main proceedings, the interlocutory application wouldn't be in existence. Even though it may finally dispose of the matter, that's not to say that it's not interlocutory. So it really is a matter that's incidental to main proceedings. Now, our interlocutory doesn't have its own case plan, case management conference, and pretrial. That's the main action that has these steps. The interlocutory is managed by the managing judge, but for that we won't find any of these 3 steps. It's managed on an ad hoc basis. All right. So a trial, an action, won't be set down for trial or hearing before a pretrial is concluded. And then it's held, and it's in Subrule 2, in terms of Form 7, you can read the requirements there. And the parties must address the issues set out in Subrule 6, the parties' proposed pretrial order, and any other issue that may promote a fair and speedy trial. So the parties are not limited to what's set out in Subrule 6. They can address more issues, and often they do, but they shouldn't address less than what's set out in Subrule 6. So Subrule 6 says it must be all issues of fact to be resolved during the trial, all issues of law to be resolved during the trial, all relevant facts not in dispute in the form of a statement of agreed facts, the names of all witnesses who may be called to testify at the trial, and the proposed dates for the filing of witness statements. The witnesses to be called by subpoena to testify, evidence taken on commission, a list of all exhibits intended to be introduced as evidence during the trial, all plans, photos, diagrams, and models to be introduced as evidence, the anticipated length of the trial, time limits for delivery of the index and paginated pleadings, any proposal for expediting the trial or hearing, particulars required for trial, prospects for settlement of the case, and the need for transfer from one division to the other. So these are the things that you need to address at your pre-trial stage. Now, let's turn for the moment to page 55 under the case management section of the file that you were given. So this is what a draft pre-trial order or proposed pre-trial order looks like. You'll see here the parties said that the issues of fact to be resolved in this matter was the negligence of the second defendant, and if so, did it cause or contribute to the collision, the negligence of the plaintiff's son, and if so, did it cause or contribute to the collision, the parties' respective quantums of damages, the plaintiff's ownership of the Suzuki vehicle, bearing that registration number, then the issues of law, whether the court should make a ruling in terms of Section 1 of the Apportionment of Damages Act, and then 3, the following relevant facts are not in dispute: the citation of the respective parties, the time, date, and place of the collision and the vehicles involved therein, that the parties' vehicles sustained damage in the collision. The first defendant is the owner of the Volkswagen Transporter vehicle with registration number that. The first defendant is vicariously liable if second defendant is held to have been negligent, and the plaintiff is vicariously liable if her son is held to be negligent. And then, now let's perhaps stop there for a moment. When you deal with the issues of law and issues of fact to be resolved, in other words, that's what you're saying to the judge, that is what the parties want the court to look at and decide. Now, if you just turn back to the pleadings, you'll find the particulars of claim on page 3 to 5. And then you'll find the plea on page 12 onwards. And then there's a counterclaim. We won't deal with a counterclaim just yet. So you'll see the particulars of claim state these are the parties. Then at all material times, the plaintiff was the owner, alternatively the bona fide possessor of a Suzuki Swift motor vehicle bearing that registration number. On or about 17 October and at Windhoek, and at the intersection of Robert Mugabe Avenue and Jan Jonker Street, a collision occurred between the plaintiff's motor vehicle, then and there driven by Marcel Josia, and the first defendant's vehicles, then and there being driven by the second defendant, acting within the course and scope of his employment with the first defendant, alternatively within the risk created by such employment, in the further alternative as an agent acting on behalf of the first defendant. And then the aforesaid collision was caused solely as a result of the negligence of the second defendant in one or more or all of the following respects, and then they list the respects in which they allege the second defendant was negligent. As a result of the second defendant's negligence, the plaintiff's vehicle was damaged and suffered damages in the amount of 144,000, being the fair and reasonable value of the motor vehicle as set out in Annexure HJ1, and therefore the first and second defendants are liable to the plaintiff. That's the claim. The defendants then answer and say they admit the citation of the parties. They admit the registration number of the plaintiff's motor vehicle, but they deny the rest. They admit that a collision occurred on that day, as set out in paragraph 5. Sorry, paragraph. Yeah, there are two paragraph 5s. Then the second paragraph 5, they deny, and they refer to their counterclaim. And they say, alternatively, contributory negligence. Then add paragraph 6. They admit the registration number and that it was damaged, but deny the quantum. Am I missing a page or two? Yes, sorry. And then paragraph 7, admit demand and failure to pay, but say that they are not liable, and therefore that the plaintiff's claim should be dismissed. Now you'll see that basically what they're saying is that the second defendant is employed by the first defendant, that a collision occurred on that date between these vehicles driven by these people, and that as a result both parties' vehicles were damaged. That's what they admit. Now, and then there's a counterclaim for negligence. Now, if you go back for the moment to the draft pretrial order, it says the issues of fact to be resolved during the trial: negligence of second defendant and negligence of plaintiff. But the negligence really is more than just the negligence, is it not? Because the negligence, if you look at page 4 of the pleadings, it's set out to say these are the regards or the respects in which it is alleged that the second defendant was negligent. So it's really much wider in the pretrial order than it is in the pleadings. So a party can't amplify his pleadings by way of the pretrial. So they will be bound by what is in the pleadings. The pretrial doesn't somehow override or widen or broaden or augment the pleadings. So a plaintiff in this respect, although it's said that it's only it's the negligence of the second defendant that must be established as a matter of fact in an issue to be determined, what will be determined is what is set out in paragraph 5 of the particulars of claim that says he failed to have regard to road users, he ignored a red traffic light, he failed to avoid a collision when it was reasonably expected of him to do so, and he drove the first defendant's vehicle without a valid driver's license and therefore illegally. These are the grounds on which it's alleged that he's negligent. So you can't then at a trial, because there's a wider reference to the issue in dispute in the pre-trial, suddenly say, but now I want to go wider than what's in my pleading. Now, the rule requires the party, when you look at the following facts not in dispute, the rule requires a sort of a stated case to say the citation of the respective parties. That really is, strictly speaking, not rule compliant. Because what the parties need to do is to draft a statement of the facts that are not in dispute. So the plaintiff is this person, the first defendant is this, the second defendant is this. This is when the collision occurred between these motor vehicles bearing these registration numbers, and the second defendant is the first defendant is vicariously liable based on this, and the plaintiff is vicariously liable based on this. So listing it in the way that it's listed here is not strictly rule compliant, although the issues are properly listed. So you see how the pre-trial ties in with the pleadings. Does that make sense? And that's what it's based on. So drafting a pre-trial order requires the parties to go to the pleadings, to establish what's in dispute and what's not in dispute. List those things that are not in dispute in the form of a statement of facts, and those things that are in dispute distinguish between what are issues of law and what are issues of fact, and then list them. It's not a regurgitation of the pleadings relating to the issues in dispute, although that does happen sometimes. Okay, so you follow that. Let me explain by way of an example in a matter that I previously had. I was a defendant, I acted for a defendant in a matter where the plaintiff had relied on certain, it was a claim for specific performance. Then it was an invalid cancellation. The plaintiff said the defendant cancelled the agreement, but it did so unlawfully, and therefore it's a repudiation of the agreement, and the plaintiff didn't accept the repudiation, and therefore the agreement is. Then, in the pre-trial order which was drafted, there was reference to something which dealt with not an election or a waiver, but an acceptance of a certain document. So the defendant said you had to provide a guarantee, and you didn't comply with that. But the plaintiff attempted to comply by granting some letter of undertaking which wasn't relevant, or which the defendant said wasn't in compliance. But the official working at the defendant received the document, and then it was pleaded to say, well, yes, we admit that he received the document, but that doesn't constitute acceptance of the document. It doesn't mean that he accepted it, he received it. Now that acceptance then, during trial, was elevated by the plaintiff, or attempted to be elevated by the plaintiff, to an election or a waiver, which is different from I have complied with the agreement to, well, I haven't complied, but you've waived your right to rely on breach. So once that evidence was being presented, I obviously objected. I said that's not the case that the defendant was called to meet by the plaintiff. So one of the things that the plaintiff tried was to say, well, this acceptance reference in the pre-trial as being an issue in dispute really means election or waiver. And then they tried to amend their pleadings to bring in the election or the waiver, which you know you must properly plead in your particulars of claim if you want to rely on that. And of course, the court at that stage didn't allow the amendment. But so a party won't be able to move outside the pleadings and amplify the pleadings by way of the pre-trial order. The parties are bound by what they set out in the pre-trial order, so parties must take care and in drawing draft pre-trial orders to make sure that they're actually in strict compliance with what is required. But if something is in the pre-trial which is not in the pleadings, it may assist a party to move for an amendment of the pleadings, because remember, the overriding objective of case management is to determine the real issues between the parties. And the court will obviously take that into consideration in an amendment, but you will have to amend your pleadings if you want to rely on something that's in the pre-trial conference but not in the pleadings. Okay. So, as I said, pre-trial conference deals with the essence of the merits. Parties will have to analyze, physically analyze, the particulars of claim, the plead, the replication, the counterclaim, the plead thereto, replication, all the pleadings filed. And will have to, from that, make a list of the issues that are in dispute, formulate them and list them. You obviously don't want to overburden by regurgitating or overcomplicating the matter. You simply formulate them and crystallize them because you want to delineate all the issues that are in dispute. Then you need to classify whether these are issues in dispute relating to fact or issues in dispute relating to legal issues, and then list them accordingly. Sometimes an issue can be a combined issue of law or fact. So when you can't really force that issue into either fact or law because it has an element of both, like negligence. Negligence is a question of law and fact. So that could be then say issues in dispute of combined factual and legal nature, and then those are listed. And then the pretrial then, if you look at what's required, gets the matter ripe for trial. So it deals with all the preliminary issues that must have been dealt with in order for this matter to be ripe for trial. That includes paginating, indexing. So it has an element of dealing with the merits and crystallizing or delineating the issues. And it also has a logistical element in that it just does the final steps. So there is authority. You can actually just look for it. It's a number of authorities, and I think the one most quoted is one by Judge Smuts while he was still at the High Court. I'll look for the citation during the tea break, where it's clearly stated the pretrial order becomes an agreement between the parties. So the parties are bound by what is set out in the pretrial, and they can't simply deviate from it. And now remember, if subsequent to pretrial pleadings are amended, it would mean that the parties would similarly have to amend the pretrial order because other issues become issues in dispute and other issues may no longer be in dispute. So that would entail also an amendment of the pretrial order. If you look at the issues that are not in dispute, so have a look at what is required in terms of rule. Look, I'm being extremely formalistic now. You, as a judge, you would obviously look at the case. This is a simple motor vehicle accident claim. It really is no effort to go to the particulars of claim and see the particulars of the litigants. That is not in dispute. So, but strictly speaking, if you look at what is required, you can look at Rule 26, Subrule 6, and then C. All relevant facts not in dispute in the form of a statement of agreed facts. So you would have to have all the facts set out in a statement form. Say these are the facts that are not in dispute, and then list the actual facts. They are simply saying the citation of the respective parties. Now, where must the judge go find the citation of the respective parties? The judge must now page back to the particulars of claim to go look for it. So the parties should strictly, as I said, I'm being very formalistic now, but that is what the rule requires. The rule actually requires you to draft this in a manner where the facts, the judge should be able, at the end of the day, to take this page of the pretrial order where it says the following facts are not in dispute, and to take those facts and literally copy and paste them into a judgment to say, these are the facts that are not in dispute, and list them. But now it's only the citation. So, okay, this is a fairly simple matter with very little pleadings, and it's easy enough to go back to the citation of the parties. But can you imagine if it's pleadings that go into 200 pages, and that often happens, and there are 90 facts not in dispute? Can you imagine if the judge now has to page back and forth to find these in the pleadings? So it's not helpful then. It's not helpful then. The purpose of this is to be helpful, to be of assistance to the court, and to make matters easier. So at the end of the day, you can pick up your pretrial order and you can look at exactly what needs to be done at the trial and what you can rely on and what you can't rely on. And you shouldn't have to page back and forth looking for facts. Of course, you need to be able to test whatever is stated in the pretrial order against the pleadings. But you would obviously be entitled to rely, or should be entitled to rely as a matter of assistance to the court. That's why I said it's not strictly rule compliant if you look at how the issues not in dispute are formulated in that example that was given to you. Yes, the parties are required to draft a joint pretrial order. But now, what has happened in practice often is that one practitioner doesn't come to the table and doesn't assist in this being drawn. Strictly speaking, a party shouldn't file a one-sided draft order. It's not allowed for in the rules. However, what I have asked practitioners to do in matters where I've acted as instructed counsel and where the opponent seems to be obstructive and doesn't want to come to the table to assist in drawing a draft report, I would draft a one-sided report and file an affidavit. Ask the practitioner to, I wouldn't file the affidavit, ask the practitioner to file an affidavit setting out what was letters that were written and telephone conversations calling upon the opposing side to come to the table and assist and their lack of cooperation. And then the court should deal with it and whether the court will then accept. I've had instances where one-sided reports were then made in order of court. The court said, well, I'm then accept you have been deprived of an opportunity now to have insight into this pretrial. I'm accepting the one-sided report. I've also had instances where parties don't agree on what should be in dispute and not in dispute. That happens more often than you would think, because someone interprets this issue to be this, and I may interpret it to be that. Very easy to deal with that. You don't need to run around and address a judge and make a decision. What you do is you can say, the plaintiff says that these are the issues in dispute. The defendant says these are the issues in dispute, and these are the issues in dispute that they agree on. Same with admitted facts. And then the judge has one of two options. Either deal with those during the trial or at the commencement of the trial and make a ruling saying on the pleadings, I find that this is the issue in dispute. Or on the rulings, sorry, Mr. Plaintiff, on the pleadings, sorry, Mr. Plaintiff, I don't see that this issue that you're formulating here in paragraph 2, that it really actually arises from the pleadings, so it's not something that I'm going to be determining. Or the judge can actually deal with that right at the outset during case management, during the pretrial conference, say, all right, I want the parties to address me on this date. I want to know, or I want to make a ruling on what needs to be decided before we proceed. So the judge really, if it's a fairly simple matter, I suppose you can deal with it during the course of evidence. If it's a complicated matter, then probably deal with that before you set the matter down for trial, because it's important to know, and the parties need to know whether this is an issue that's going to be decided or not, because it will inform a lot of preparatory steps and also how the case is presented. So it has happened in the past. Sometimes these are just parties being overly formalistic and not wanting to, and it doesn't really take, it's neither here nor there. Sometimes these are important issues that need to be determined. For instance, in the example I've given you, if the plaintiff had thought that the reference by a defendant in a plea to acceptance or denial of acceptance then somehow translates into election or waiver, then, and they had listed that as an issue, the court would have had to decide right at the outset whether that was actually an issue in dispute, because I would never have agreed in that scenario for that to be listed as an issue in dispute, because it wasn't on the papers. So if there had been a disagreement between the parties, then the court would have had to decide that right at the outset before the matter proceeds. So you see how it's very important. So a pretrial can become extremely complicated, and it can also be the simplest thing in the world. Depends on the matter. So what I'm saying is I'm being overly formalistic, but I want you to understand that the rules are there for a reason. And even though the court in this instance accepted this pretrial and made it an order of court, it doesn't mean that all pretrial orders can and should look like this. It depends on the circumstances of the matter. I suppose if there are grounds for review, if you feel that one of the grounds for review, you'll be dealing with review and the grounds for review in your motion section, so I won't go into detail of that. But if you feel that the judge has misdirected himself or herself for whatever reason and there's grounds for review, then you have recourse in terms of Section 16 of the Supreme Court Act to, of course, apply for a review of that decision. It's an interlocutory decision, which I don't know if you've read the authority I referred you yesterday to, the Savinu versus Nedbank. So it's questionable. It goes back to, it's an interlocutory ruling which the court makes. I think it would be similar to a judge admitting a document into evidence which you've objected to. You can't, even with leave, you can't appeal to that. You'll have to wait for the trial to proceed and to finish, and then on appeal, that would be one of the reasons why you appeal. So you'll deal with that on appeal, because it may very well be that despite that, the trial proceeds and you are still successful. So that's why the rationale regarding appeals at that stage is limited. So even if you obtain leave to appeal that, probably questionable whether the Supreme Court will actually entertain that appeal, because the authorities suggest that in that instance you shouldn't be able to appeal at that stage yet. And the Savinu matter, the authority, its judgment given earlier this year, makes it even more difficult for parties in interlocutory decisions to appeal to the Supreme Court. Because what they want to try and avoid is that during this process of a trial, you run to the Supreme Court all the time. All right, so it's an important consideration. You don't want to take the party's right to approach the Supreme Court away, but you don't, because the party can proceed and the Supreme Court can then review the whole process and say, well, this shouldn't have happened. You should never have allowed this to be an issue in dispute, and therefore the appeal should be successful, or whatever it is. So questionable whether you'll be able to appeal that. Such a decision. Okay. So, pre-trial. So, then the list of the witnesses. Please remember, and I'm going to again refer you to the authority of Smuts, Judge Smuts. You are bound by the pre-trial. So, if you have left out a name of a witness, then you would not be entitled to call that witness at the trial. When you haven't filed a witness statement, you will not be called or allowed. In this instance, witness statements had not yet been filed at pre-trial stage, so the parties agreed to file by 25 February 2015. Then they say no witnesses to be called by subpoena. You are strictly speaking required to list the witnesses by subpoena. What I have seen happen in the past also is that parties reserve the right to subpoena witnesses and will do so in terms of the rules, and they reserve that right, and then they proceed to call subpoenaed witnesses left, right, and center, probably not in keeping with the spirit of the rules. Parties should actually prepare in advance and list the witnesses they intend to call by subpoena. Now, you don't have to call a witness that you've listed in the pre-trial, so you may list all and sundry and only call 2 witnesses. That's fine. You're not obliged to call a witness that's listed in your pre-trial. Whether the court will make an inference from not calling a witness, that depends on the circumstances of the matter. What happens often, you have all the witnesses listed, but then by the time you get to the second witness, you realize that these issues are no longer in dispute. They are sort of conceded during cross-examination, and then you may not call further witnesses on an issue that you were intending on corroborating previous witnesses' evidence, and then you may decide not to call them, which is actually the prudent course, because you shouldn't waste court time on issues that are no longer in dispute. If something happens, and they do, trials are very much alive and they very much develop as they go along. And very often issues arise during the course of proceedings that you didn't anticipate, or evidence becomes required that you didn't anticipate would be required. And we all, as I said, don't have crystal balls, and hindsight is perfect vision. So if you then are faced, if a practitioner is then faced with the position that he or she wants to call a further witness, you would have to do so with leave from the court. You'll have to amend the pretrial order. If it's a subpoenaed witness, get that name into the pretrial order. If it's a witness for whom you can file a witness statement, then seek leave to file a witness statement and to amend the pretrial to include the name of that witness. And the court will then take a number of things into consideration, especially why this hasn't been done previously, why it's only coming at this stage, at a later stage. Because if parties are left, right, and centre allowed to just amend pretrial orders as they wish and at any given stage, then they would pay very little attention to the preparation of the pretrial order at the beginning, as they should. All right. We'll deal with sanctions after we, I'll give you a comfort break in a moment, and then we'll deal with sanctions for the remainder up till tea break, and then we'll deal with contempt and non-compliance and what a judge can and cannot do in those circumstances. So essentially, when a pretrial order is granted, it is an order proper. It doesn't dispose of the matter. It creates certain obligations on the parties, and it binds the parties in other respects. So it's a court order, and non-compliance with that, of course, amounts to contempt if there was an obligation to comply and there wasn't compliance. So as I've explained to you earlier, indexing and pagination is an obligation. A party doesn't have a choice. If they've agreed to that and it's been ordered that it must be done at a certain time, it must be done. Failure to do that will render that party in contempt of court. Dominus litis does indexing and pagination unless the parties agree otherwise or the court orders otherwise. Although the dominus litis, the plaintiff, has the responsibility to engage the other party in the case management process, where a plaintiff doesn't do so, defendant can't sit back and say, well, then I'm not going to do anything either. The responsibility is just as much on the defendant to actually take part in the proceedings and to then act where the plaintiff fails to act. Now, of course, a defendant isn't going to do something to further the case of the plaintiff. I mean, that would be unfair to expect. But the defendant cannot simply sit back and say, well, I was waiting for the plaintiff, so I'm not doing anything. All right. Okay, so that, in a nutshell, is the pre-trial conference. You'll see just one short note on list of exhibits. The parties, you'll see on page 57 of the example given to you, the lists of exhibits as specified in the parties' respective discovery bundles. Now, strictly speaking, that's not correct in the sense that the purpose behind that is to say which of these documents that you've discovered do you intend to introduce as exhibits during the trial. So I've spoken about a trial bundle earlier, I think it was yesterday when we did discovery. I mentioned to you that I tend to like to prepare a trial bundle, if possible in cooperation with my opponent, to say these are all the documents we intend to introduce. So yes, we have 70 lever arch files of documents, but only one lever arch file is going to be used, and then ideally you should either list them under this heading or have an annexure to the particular to the draft pretrial order where you say these are the documents that I intend to introduce as exhibits. Why the parties do this, this wide sort of all the discovery bundles, is because they don't want to lose out on a right to introduce a document. But you can still have a rider to say these are the documents now identified, but the parties reserve the right to introduce any further documents properly discovered. Okay. Do you follow? And then they deal with plans, photographs, diagrams, and models. Which of these? Anticipated length of the trial. You would say a witness, a substantive witness takes about 2 days to finish in examination in chief and cross-examination if it's a matter of magnitude. In a motor vehicle accident, you'd probably be able to finish about 2 witnesses a day. So here they have 4 witnesses each, so let's say 4 days. So then they say anticipate. The parties are not held to that. It's just to give the court an idea of the magnitude of this matter. Often matters. I've had trials continue for 4 weeks, which we thought was going to take 3 days. It happens. Filing of index and paginated bundles of pleadings, expediting the trial, none at the moment. So expediting the trial would be to say, I think we can agree on this. These are the two experts' reports, and the experts have met, and they agree on these issues, so we don't need to cross-examine on that, or any possible fathomable manner in which the trial may be expedited. And here they said they don't require further particulars for trial. And then settlement and ADR set out therein. And then that is essentially what a pretrial order looks like. And you'll see on page 60, or draft pretrial order, that pretrial order well, here, for some reason, the pretrial order was not made an order of court, but strictly speaking, it should be made an order of court to bind the parties thereby. So what the court did here was to list the obligations going forward in an order, but not to make the pretrial order an order of court. So I think it would be prudent to do that. All right, so that takes care of case planning, case management, and pretrial conference, the judicial case management system. So we'll deal with sanctions. It's 9:32, so let's be back here at 9:38, and then we'll proceed with sanctions. And when we're done with that, we'll move over to interlocutory proceedings for the rest of the day.